Well, welcome to the BreakPoint podcast. We are going to have a conversation about one of the most significant Supreme Court cases in this term, probably easily in this term, and may end up being one of those that has significant consequences for years and years and years to come. If you follow BreakPoint on Tuesday, we talked about a Supreme Court decision having to do with employers' rights in Title VII. Something we've been discussing for a long time on BreakPoint is whether civil rights legislation would be expanded. Civil rights categories in the Civil Rights Act would be expanded to include sexual orientation and gender identity. And a decision that was released earlier this week, actually on Monday, that's exactly what the Supreme Court did. And just really pleased here to talk to John Bursch. John is a senior counsel and vice president of appellate advocacy with the Alliance Defending Freedom, and one of the attorneys representing the Harris Funeral Home side of this case. And John, I'll let you parse all this out for our audience here as we go forward. But you argued this case, and I know you're disappointed in in what we got, and I think a lot of us are, in particular, disappointed that the decision was written by Neil Gorsuch, which says a lot about the makeup of the court. I don't know how much you're willing to say about all of those things, but first, let me just say thanks for being casual and not wearing a coat with that wicked-looking bow tie that you have.
Thank you, John. I appreciate that. I decided to go casual today.
That is a casual look for you. John, set up for us just how this case was put together. We had three different parties, two individuals whose employment had been terminated. They claimed because they were gay, and then one who had changed from being a man to identifying as a woman. Talk about how all of this came together in Title VII, and just give us the 30,000-foot view.
Yeah, you bet. Title VII is the federal law that prohibits discrimination in employment because of 5 enumerated categories. Ethnicity, race are ones we're all familiar with. Religion, we don't hear about as much because the courts don't seem as interested in protecting religious rights these days. But one is sex. And so these cases came about because advocates for the LGBT community had tried for decades to amend Title VII to add protections for those based on sexual orientation and gender identity. And they had failed over and over and over again. The quest to add sexual orientation to Title VII took more than 50 proposed bills, and it was at least a dozen where they tried to add gender identity. So even as they were using sexual orientation and gender identity concepts in other federal statutes and in numerous state and local jurisdictions, it never happened in Title VII. And so what did the activists do? Well, they turned to the court system instead and asked the court to rewrite the statute to include those things. So as you mentioned, the case came up to the US Supreme Court as a set of 3 cases, 2, Bostock and Zarda, involving the sexual orientation question, and 1 involving my client, Harris Funeral Homes, and Tom Rost, involving the gender identity question. And the opinion that they released addressed all of those in one fell swoop. And what the majority opinion, written by Justice Gorsuch, said is that when you treat someone differentially because of their sexual orientation or their gender identity, you're necessarily treating them differently because of sex. Now, that's an absurd proposition, and I'm happy to get into why that is, but that's the 30,000-foot view of what happened.
Well, that was kind of the unexpected thing that happened too, right? I mean, everyone kind of seemed to think that this whole case was going to hinge on whether the word sex was going to be expanded to include sexual orientation and gender identity. What Justice Gorsuch seemed to argue was that, no, it didn't include those, but that you actually can't talk about sexual orientation and gender identity without talking about sex, or you can't actually discriminate. In other words, it seemed to be kind of a rhetorical, I called it in my commentary on Tuesday, a rhetorical jujitsu, and maybe a distinction without a difference.
Yeah, I think it's both of those things. And you can use a couple of mental exercises to determine whether that's true or not. Imagine that you had an employer and they had a box to check on the employment application as to whether you had heterosexual or other sexual orientation. and another box that indicated whether you were transgender or had a gender identity other than your biological sex, but did not ask you for your sex itself. So they had no idea whether you were male or female. The statute prohibits discrimination because of sex, which even Justice Gorsuch acknowledges means male or female, biologically determined, objective, and unchanging. So in that situation, the employer could hire someone because of how they felt about that person's gender identity or their sexual orientation, knowing absolutely nothing about their sex. And yet Justice Gorsuch says it's impossible to not connect those concepts. He's just wrong. Or an example that Justice Kavanaugh used in his dissent, or a slight variation on it. Imagine that you had 4 applicants and 2 were women and 2 were men. And one of the women was heterosexual, one was same-sex attracted. In the men, one identified with the male sex, the other had a different gender identity. He identified as a woman or something in between or queer or whatever. If the employer decided not to hire the women and hire the 2 men because of their sex, that is sex discrimination. But if they decided to exclude the person because of their orientation or their gender identity, that doesn't have anything to do with their biological sex. It only has to do with that other trait. And yet now those traits have been written into the statute by the U.S. Supreme Court.
So, I mean, in a sense, let's say, and I was fascinated by Justice Kavanaugh's, scenario there, because Gorsuch wanted us to choose between 2, but Kavanaugh said, let's expand it to 4. And you could see in that situation where any choice would be a violation of Gorsuch's interpretation of Title VII, right? No matter what you do, you're either discriminating on the basis of sex or you're discriminating on the basis of sexual orientation, which according to Gorsuch, you can't do unless you've already discriminated on the basis of sex.
Right, exactly. And where that makes the least amount of sense is in the gender identity concept.
Right.
Because if you're an employer and you have sex separate showers and restrooms and locker rooms, you're necessarily identifying people by their biological sex and saying, you're allowed to use this shower, you're not allowed to use that shower. And Justice Gorsuch's conclusion is that if you do that, you have discriminated based on sex, which is absurd. Keep in mind that his whole frame of reference here, how he was interpreting the statute, was according to its original public meaning, how the average American schooled in English would have understood Title VII in 1964, the year that it was enacted. And so to say that someone in 1964 would have read that phrase, no discrimination because of sex, and concluded that employers could not have sex-separate showers, or that a professional basketball team in the WNBA could not keep biological men off of the team because it was a women's league, is just nonsense. There's not a single person in the United States that would have believed that.
Well, I want to get into the implications and where this is going to go. And I know, predicting where Supreme Court decisions are later applied is a dangerous game, or it's kind of hard to see. But I want to get into the reasoning itself, because there was a real distinction between, it seemed to me, what Gorsuch was trying to do. So in so many of these cases, if you go back to the Obergefell case, if you go to, maybe not so much the Obergefell case, but certainly the Jack Phillips Masterpiece Cake Shop case, the court seemed really reticent on these issues to do anything sweeping. Any sort of kind of sweeping Roe v. Wade sort of culture war, decision that was going to change, the kind of the course of anything. Justice Gorsuch said, look, this won't have anything to do with bathrooms or sports teams. He actually went through this whole list of everything that it won't have anything to do with. Then Justice Alito, in his dissent, turned around and said, yes, it will, and here's why. It seemed to me, though, that what Gorsuch was trying to write was a very narrow decision, but in reality, we called it a broad decision masquerading as a narrow decision. Like, sure. This is going to be one of those things you can't keep kind of the cat in the barn. And it was just kind of a strange way he was trying to do it, like arguing as a literalist. Arguing according to the actual meaning of the word sex, saying, I'm taking the 1964 understanding of sex as being biological, but even in that case, you can't have a man do something that you wouldn't, that you would allow a woman to do, and vice versa. So it seemed to me that he was trying to do something narrow, but at the end of the day didn't.
Yeah, it was a spectacular failure at trying to write a narrow opinion. And I think your instinct to compare it to Obergefell was the right one, because you remember that the promise of the other side leading up to
Right.
Obergefell,
Kennedy made the same promise, didn't he?
right,
Kennedy said the same thing. Yeah.
right, and that redefining marriage wasn't going to affect anybody. But, talk to Barronell Stutzman, talk to Chief Cochran, talk to Blaine Adamson, talk to all these folks who have had their livelihoods put at stake in litigation by states and plaintiffs who are trying to punish them for their views on marriage. And we can all look back with 2020 hindsight and say that's not true. And here it's even more not true. So, Gorsuch says in the opinion, we're not deciding today the shower and the restroom question. But the test that he applies absolutely decides that. And Justice Alito pointed that out. If you're saying that a biological man is not allowed to use the women's restroom or the women's shower, but a biological woman is allowed to use the women's shower, and the man identifies as a woman and now wants to use that shower, and you say no, that is discrimination based on sex, on his own reading of the statute, because the man is being treated differently than the woman. Well, again, no one would have thought that in 1964. So to somehow claim that this doesn't affect that is just sophistry. I mean, even he must know that's not true. And Justice Alito's dissent went on for more than 100 pages with a pretty large appendix, documenting the many, many ways this is going to sweep across federal law and change the way we think about all kinds of things. So it's really inevitable that this is going to have a big impact. And Justice Gorsuch knows that, and we know that, because at the very end of the opinion, he holds out to the olive branch to people who still hold a biblical understanding of what it means to be male and female, or a biblical understanding of marriage. He says, oh, well, there's still religious liberty protection out there. So as courts go on and implement this, saying that anybody who holds those biblical views is a discriminator, they might be able to defend using religious liberty. And so what that does is it sets us up for a culture war in the courts that's going to last probably the next 15 to 20 years, where we're going to have to litigate case by case every employer, employee, student athlete, professional athlete, anything having to do with these issues, and determine what trumps. Is it the right to religious liberty, or is it the anti-discrimination provision that he just rewrote? Well, and so there's nothing narrow about this.
Yeah, I mean, and it's really hard to imagine that the end game here is not going to be this strict line drawn between what counts as a religious organization and what counts as a non-religious organization, right? In other words, treating nonprofits, religious nonprofits, and that basically amounts, as we've talked about a lot, essentially some sort of national version of the Utah Compromise or something like that, right? Where if you're a person of faith, you can't be for profit and still hold your religious, or you have to check your religious liberty at the door if you are for profit, and it only applies to religious nonprofits and churches. But we remember back in the Obamacare mandate, the HHS mandate, what the government decided counted as a religious organization that could hold on to its conscience when it came to distributing birth control pills or abortifacient pills was really, really narrow, right? I mean, and didn't even count for, larger churches or churches that provided any sort of public health services and that sort of thing. So do you foresee then, as this culture war then gets picked up and new lines get drawn, that's really one of the things, you're thinking about people like Jack Phillips and Barronell Stutzman, these names that you mentioned. They're not in the nonprofit world, they're in the for-profit world. Do you foresee that kind of freedom, religious freedom, being neutered down to only those who are in kind of religious jobs?
Well, I'll give you a reason for optimism and a reason for pessimism on that.
Good.
The reason for optimism is that Title VII is a federal law, and so the Religious Freedom Restoration Act applies. And that was the same statute that guarantees religious liberty that Hobby Lobby invoked, even though it's a for-profit company, in the context of the Affordable Care Act contraceptive mandate that you were just referencing. Right. The U.S. Supreme Court, by 4 decision, no reason to think that they're going to backtrack on that, said, yes, RFRA applies and it protects Hobby Lobby. So great, that's the good news. The bad news, and the reason why Alliance Defending Freedom has opposed the Utah Compromise and similar compromises in other places, is because by moving the ball to a fight over religious liberty, we have now said as a matter of law to hold beliefs about marriage and gender and human sexuality that are consistent with the Bible is discrimination. It's hateful and bigoted. Now, we might give some of those hateful religious people an exception because the Constitution and this RFRA statute tell us that we have to do that. But when you think about the political and cultural trajectory of this country, how long do you suppose that that religious liberty exception is going to last when everybody thinks that this is a bigoted and hateful view? And so that gets me to the point of all the work that we have to do. It's not going to be enough in the next 20 years to simply fight the battle for religious liberty and invoke that statutory defense, to invoke free exercise clause. We need to re-educate the culture as to what the meaning of sex is, what the purpose of human sexuality is, and the importance of embracing all the gifts that God has given you, from your body to your human sexuality to your orientation to everything that goes with it, and to live a life that's aligned with His plan, not with our own personal feelings and what society says is right or feels good. Because until we can win that latter point, we're just going to see a downward decline and a long-term diminution in religious liberty protection, as long as people think that our views are not about love, which they are, but instead are about hate.
Yeah, I'm so glad you brought up the whole the upstream work in culture, because this is a decision to me, especially when I read through Gorsuch's opinion, and he's trying to be kind of a traditional textualist conservative, and then saying, well, then you can't really say that it's wrong to ask a woman, to dress like a woman if, or you can't really say that it's okay. How do I want to say this? You can't really say that it's wrong if you allow a woman to dress like a woman, for a man to dress like a woman. And
Right.
that's, now we're speaking of cultural norms. Now we're speaking of things that, as you said, would have been unimaginable. And not even back in 1960, whatever. I mean, we were assured at the Obergefell decision that the transgender issues would not be part of the ramifications of this. John, it seems strange to me at some point that these three cases were put together as if they were the same thing, as if when we're talking about whether what sex means, the word sex means in federal law, when it's always been understood to be biological sex and so on, that we should be able to, that the Supreme Court should have treated gender identity and sexual orientation as if they're the same thing, as if you can decide them on the same wavelength. I mean, we even saw last week with J.K. Rowling, right, that even the L's and the G's and the T's don't always agree across the board.
Yes.
Did you think that was a strange move for the court to pull those three cases together as if they were the same thing and not treat them separately?
Well, yes and no. If you were thinking about judicial efficiency, it made sense to package them because they all involve the same core question: what is the meaning of the phrase discrimination because of sex? And then you're simply applying it in different contexts. But at a bare minimum, the court should have teased apart the differences between analyzing sexual orientation on the one hand and gender identity on the other, because of this conclusion that Justice Gorsuch now reaches, that somehow even taking sex into consideration when you're establishing a sports team or when you're saying who gets to use the shower is itself sex discrimination. That's an argument that doesn't necessarily map onto the sexual orientation side of the cases, and yet he just kind of melded and blended everything together as though it made no difference. I think that was wrong legally. I think culturally it was disastrous. And his opinion really betrays that he himself has already bought the cultural narrative today about gender identity. Because when he referred to Stevens, this is the funeral home employee who wanted to dress as a member of the opposite sex, he did not refer to Stevens based on Stevens' biological sex, but on that identity, and said that Stevens, who was born a male, that she, at the time of hire, was identifying as a male. Well, we all know that Stevens wasn't identifying as a male. Stevens was a male. Stevens had the chromosomes and the DNA and the bone and muscular structure and the brain of a male human being. It doesn't take a rocket scientist to figure that out. A coroner looking at someone in an examination can tell you whether that person is male or female, and Stevens was male. But yet he bought hook, line, and sinker that entire ideology. And as soon as you do that, then all of a sudden questions about sex become much more difficult.
Yeah. Well, it's astonishing to me that in the highest court of the land, that sort of blatant non-truth would be assumed as the language to be used, as the frame of reference to be kind of built upon. That to me
Yeah,
again says an awful lot. I mean, that's a remarkable thing. I mean, we're not talking about a politically correct professor at such and such a university, or a news media personality trying to not offend Caitlyn Jenner, who's sitting in front of them with an interview. I mean, we're talking about a Supreme Court justice, the highest court in the land, that in the language of the decision assumes the other rules of the game, and just says things that aren't true. Like you said, Stevens was not a woman identifying as a man. Stevens was a biological, chromosomal, genetically and physically distinct male human being at the time, and that's a remarkable way to say it.
yeah, and it sounds crazy and frustrating and depressing that the Supreme Court itself would be talking that way.
Right.
It's not like this is the first time that's happened. I mean, what happened to the clump of cells or the fetus instead of the baby that's growing in utero? Or what happened to the longstanding definition of marriage, which all of a sudden became more about emotional commitment than about the commitment to someone to procreate and to rear and raise kids. The court has a long history of adopting whatever language is convenient to the cultural norm that it wants to put its imprimatur on, and it happened again in this case.
Yeah. Let me get you to do a little bit of what would you say? So we have a video series called What Would You Say? And every video starts by going, you're in a conversation and somebody says, what would you say? Right. So we've got about, 30 or so videos out on YouTube, and we'll link to them at breakpoint.org. But I was thinking the same thing, because as we talked about this over the last 24 hours, at least on social media, I'm hearing back, well, one guy tweeted, well, so you're saying gays shouldn't be able to be employed? Gays shouldn't have protections when they're employed? And I think that's what the narrative is that people are hearing. This is a landmark win for LGBT rights. It is a protection on their employment that should have been there for a long time, and so on and so on. So what would you say when somebody says that to you?
I would say two things. Number one, I would say that the job of changing a law, rewriting it, altering the meaning, is one that only Congress and the president have the power to implement. You go back to Schoolhouse Rock and everybody's fifth grade government class, and we all know that the judicial branch is not in the business of rewriting the law to judicially update it to reflect modern mores and cultural decisions. That's simply not its role. And here the Supreme Court got out of its lane and it revised a longstanding federal law. Justice Alito, in the very opening two sentences of his dissenting opinion, could not have put it better than anyone, that the court was not judging, it was engaged in legislation.
Right.
So that's the first thing that I would say. Whatever you think about the underlying rights issue, the court was not the body that should have done this. Congress should have. The second thing I would say is that people, because of where the sexual revolution has taken us, have forgotten some basic truths about the human body and the institution of marriage. And that the fact that some people have different views doesn't make them bigoted or necessarily even wrong. It's representative of ideological diversity that should be respected. And it's not hateful or bigoted to say that biology matters and that people were created, male and female, for a reason, and that there are long-term adverse consequences to those who try to move against that tide and make themselves something that they're not. In the same way that an understanding of marriage as between one man and one woman for the purpose of coming together and having children and rearing them together as long as possible is a definition of marriage that is not mean-spirited, bigoted, or hateful in any way. Both those views of human sexuality and of marriage are ultimately oriented towards human flourishing. And so if we really love other people and want what's best for them, we don't necessarily just go along with whatever they think is best, but we truly want what's best, then that's to follow God's design for human sexuality and God's design for marriage. And no American, no matter their views on the LGBT rights issue, should punish someone for holding that loving religious view.
Yeah. Well, listen, a tough go. Give us an update on the family, and I'm blanking on their names. The family that owns the Harris Funeral Home.
Yeah, it's Tom and Nancy Ross,
Tom and
and
Nancy Ross, right? Yeah. Sorry. What is the what's their status now as business owners? What's this mean for them in the long term?
well, what's going to happen to them will be determined in a further court proceeding back in the district court, and part of that will determine or depend on how magnanimous the ACLU is in this case. You know, they've got the ability to walk away and say they won the cultural victory that they were looking for. This was a test case for them. Or they can be vindictive and punitive and try to go after everything that the Ross family owns, which would be tragic. So in part, that's up to them. Now, as for the family themselves, they're obviously disappointed with the ruling. They've been litigating this for 7 years, and their heart and soul is in this. But when I talked to Tom, what he expressed to me was a sense of gratitude. He said that over the last 7 years, they have been blessed with so many relationships, so many wonderful people that God has sent into their lives to be with them, minister to them, to pray for them. And it has made such a tremendous difference to their family that almost seemed to be of greater significance than the courtroom loss, as significant as that would be. It was really a testament to their faith and their trust in God that in the end, victory's already been won. And we're not here to win cultural victories. We're here to win souls. And so I think that should be an inspiration to you and to me and to everybody listening out there, that we don't give up just because of another Supreme Court speed bump.
Well, and I appreciate that about the Alliance Defending Freedom. You guys have had that attitude from your founding, and it continues on to today. You can find out more about the Alliance Defending Freedom at adflegal.org. My guest, John Bursch, Senior Counsel, Vice President of Appellate Advocacy at the Alliance Defending Freedom, and represented Tom and Nancy Ross there at the Supreme Court in this court case that was decided this week. John, really grateful for you kind of coming and kind of shedding light on all this and helping us to kind of think through this and talk through this. And I'm really grateful too for your long-term perspective. Hang in there, keep up the good work. And thanks for joining me for the conversation today.
My pleasure. God bless you and your ministry, John.